Thank you, Michael. Thank you, Ilya. It's a great pleasure to be here at the inaugural program at the Cato Institute's F.A. Hayek Auditorium. To see all of you out here, it's a beautiful facility. I hope to come here many times again in the future. It's also a great pleasure to be debating my friend Elizabeth Wydra, someone with whom I've debated this issue on numerous occasions in the past, and someone with whom I co-authored an amicus brief to the Supreme Court defending the individual right to keep and bear arms against the city of Chicago, which the Constitutional Accountability Center supported in filing that brief. And I think they're to be commended for that act of commitment to the original meaning of the actual Constitution. Today, I'm charged with giving you a briefing, an overview of the lawsuit that you're going to hear next week. A lawsuit that, as Ilya told you, is going to consume 6 hours of argument spread over 3 days. That's the longest argument time being allotted in 47 years. No matter how this case is decided, no matter how the court comes out, there's already been one claim that has been definitively refuted by the fact that the court granted 6 hours of oral argument spread over 3 days. And that is that the challenge to the constitutionality of the Affordable Care Act, and in particular the individual mandate, is somehow frivolous or an easy case, which you actually still hear in the media, even this week. I can just assure you that the Supreme Court does not have to dedicate 3 days of oral argument and 6 hours of argument to hear an easy case, to resolve an easy case, to dismiss a frivolous claim. But that is what 99.9% of my colleague law professors were saying when this challenge was first brought, when these arguments were first made, when this challenge was first brought, and all the way up until today. And at the end of this talk, I'm going to say a little bit about the spin that you've been hearing, or at least many people have been hearing in the press this week, about how the conservative justices on the court must rule if they're supposed to be consistent with the rulings that they've made in the past, which is a complete myth, in my view. But to begin with, I'm just going to summarize the case and summarize the arguments against the individual mandate. But for those of you who don't follow this case as closely as we on this panel do, let me just summarize how the argument's going to go next week. So on Monday, the court is going to hear 90 minutes of oral argument discussing the issue of the Anti-Tax Injunction Act, which is a provision of law which basically says that you can't challenge in a collection of a tax in advance of that tax's collection. You first have to pay the tax, and then you have to sue for a refund. And the question is whether that statute would apply to the penalty of the individual that's provided to enforce the individual mandate. On the second day, Tuesday, the court's going to hear oral argument for 2 hours about the constitutionality of the individual mandate. That's double the normal argument time devoted just to that single issue. On Wednesday in the morning, the court's going to hear 90-minute worth of argument on the severability question. That is, whether if you strike down the individual mandate as unconstitutional, how much of the rest of the bill, if any, must be struck down. Some of it, the insurance company regulations, for example, or all of it. By the way, I represent the National Federation of Independent Business, the private parties that are challenging the mandate. We believe on that issue, we agree with the district court that held that if the mandate goes, the entire act must go. The government concedes that if the mandate goes, the health insurance regulations that Michael just told you about, they also have to go. And the court had to appoint an amicus, friend of the court, to argue the position held by the 11th Circuit that the mandate can be struck down alone and the rest of the bill remains up and running. That's an argument that's going to take 90 minutes on Wednesday morning. And on Wednesday afternoon, a very important challenge to the constitutionality of the Medicaid requirements that are being imposed on the states will be heard in the afternoon for 1 hour. And that is the topic of this afternoon's panel here at the Cato Institute. In today's talk, I am not going to talk at all about the Anti-Injunction Act. I think some of you will be relieved to hear that. I'm not going to talk about severability unless you want to ask me about that if there's any time for questions, and I'm not going to talk about the Medicaid challenge. I'm simply going to lay out why it is at the fundamental level the individual insurance mandate that requires every person in the United States to purchase private health insurance is unconstitutional. Now, as you can well imagine, this is a very technical issue involving a lot of precedents, the reasoning of a lot of cases, a lot of technical text, and that's not something that can be effectively presented orally in what I probably have is about 8 more minutes. So what I'm going to do instead is I'm going to just basically give you what I consider to be the 4 most salient reasons why this lawsuit, contrary to the opinions of the experts, this lawsuit did have legs, and this lawsuit is serious, and this lawsuit is going to be a very difficult one, not an easy one for the Supreme Court to decide. And I'm going to make 4 points that will involve 4 words. They'll organize around 4 words. 1, the first word is unprecedented. The second word is uncabined, which is a word that lawyers like to use to say unlimited. The third word is unnecessary, and the fourth word is dangerous. Unprecedented. Well, you've heard about unprecedented. You've heard on the issue about unprecedented. This mandate, this claim of power by the United States Congress is literally without precedent. And what I mean by that, to translate this into ordinary language, is it has never been done before. That's what I mean by unprecedented. Never in the history of the United States, to enforce any other law, has the Congress claimed the power to require that all American citizens enter into contracts and do business with private companies. And they certainly have not claimed that under the Commerce Power, which is what they're doing now. So this is an unprecedented act of power, and not only, I mean, there's 2 ways of establishing that. One is I can ask all of you in this room to think of any other contract that the federal government requires you to enter into upon pain of a penalty payable to the IRS. None of you can think of any, nor could your parents, nor could your grandparents, because this has never been done before. And every court who has decided on this case has agreed with that. The courts that have struck the law down have said it was unprecedented, and the courts that have upheld the law have said it's unprecedented. Now, what difference does that make? It is very true, as defenders of the law say, that just because something has never been done before, that does not automatically mean it's unconstitutional. There's a first time for everything. And before Congress does something that's constitutional for the first time, we have to find out if it's constitutional. So the fact that it's unprecedented doesn't automatically make it unconstitutional. But it does mean, number one, that there's no direct authority that says the Congress may do this. So that's true. Right off the bat, we're talking about what we call a case of first impression. And the second thing is a proposition of law that Justice Scalia observed in the Prince versus United States case, which involved the enforcement of the Brady Act. And what Justice Scalia said, and in that case, what Congress was trying to do is force local sheriffs to do background checks on prospective gun purchasers, even though local sheriffs work for the counties of their states. They don't work for the federal government. And that was an unprecedented claim of power as well. And what Justice Scalia said is that if for 200 years a power this attractive has gone unused by Congress, that is a pretty good argument that that power does not exist. And the same thing can be said about the individual insurance mandate. If for 230 years the Congress has gone and solved all kinds of free rider problems and all sorts of cost-shifting problems, and we've fought several major wars, and we've fought wars on poverty and wars on drugs, and we've done all of those things without having to impose an economic mandate in the past, even though that would be a very highly attractive power. Rather than paying you cash for your clunkers, we could just go make you buy a new car. And then we wouldn't have to pay any money out of the public treasury. Even though that's a very attractive power, Congress has never sought to exercise it. That's a good argument, actually, for why the power probably doesn't exist. So there actually is a constitutional significance to the fact that this law is unprecedented. Second, the law is uncabined, or it's unlimited. So far, the government, and this has really been quite remarkable to me, in the 2 years in which this case has been argued and litigated, the government and its defenders have been unable to come up with a single limiting principle on the exercise of the power to impose economic mandates of the people. At oral argument in the Sky 7 case, in the D.C. Circuit Court of Appeals, the justices pressed the government attorney for 10 long minutes to give a single example of a mandate that the government would be unable to impose on its theory of why it can impose this mandate, and the government's attorney was unable to provide a single one. I was recently told by a reporter that in a press conference when the Justice Department was filing their briefs in this case, the reporters asked them what the limiting principle was for this power, and the Justice Department lawyers were unable to answer their questions. The reporters repeatedly asked them this question, and the Justice Department lawyers grew somewhat frustrated at the inability of the reporters to take no for an answer, that we don't have an answer to the question of what the limiting principle is. It is just a fundamental principle of constitutional law that the federal government and the Congress is one of limited and enumerated powers, and unless you can state that limit, then that's likely to be a losing argument in court. Now, there is one thing that the defenders of the bill do say when the issue of limits come up, and the government says this in their briefs, and every defender of the bill will say this at some time or another, and that is, although I think Elizabeth doesn't actually say this, so you won't necessarily hear this from her, but every other defender of the briefs of the law says this, and that is that somehow health care is different. There's something about the health care market, there's something about insurance, there's something that's distinctive about this particular thing, and for that reason, that distinguishes this from everything else. And whenever you hear anybody say that, what you have to remember is that even if that's true, and by the way, it's not, but even if it were true, that would not provide a constitutional argument. It would not provide a constitutional limit. That is, the response to that is, okay, fine, health care is different. Now, what's your constitutional limit on the imposition of this power? And why is that? Well, because the court is simply not, the next time an economic mandate is being used by Congress, going to have a fact-based inquiry in which they decide whether the next act of imposing an economic mandate is like this one, whether the next market is going to be sufficiently similar to the healthcare market in order to justify an economic mandate in the next case. And that's because the Supreme Court just doesn't get into factual inquiries like that. And they won't in the future. So this is just a smokescreen for having no limiting principle at all. And if you don't have any limiting principle, then that means that upholding the mandate is going to pose a serious threat. In fact, it's going to end the system of the limited and enumerated powers that we've lived with in this country since the founding. The third reason why there's a problem with this law is that it's unnecessary. Congress had powers that it could have used to accomplish very nearly what it was trying to accomplish here. Not the same way, they didn't just have to change the name here or there, but they really did have powers, very powerful ones, the ones they always use to subsidize activities that they don't have the power directly to command, and that is their taxing and spending power. And yet they chose not to use those powers. And why is that? Well, we know why that is. It was political, which is exactly the constraint that exists on the taxing power. And that is the president ran for office saying that he would not raise taxes on people making less than $200,000. The Democrats in the Senate, the 60 Democrats in the Senate, were not prepared to support any kind of tax increase. And as a result, they didn't use the power that they had for strictly political reasons to accomplish what they say they want to accomplish with this bill. Because it's unnecessary, it is simply not a justification that, in other words, it is not a justification that you have to use this mandate because it's the only means that's necessary when Congress had the power that they could have exercised to solve this problem, and yet they chose not to. However, had they done that, it would have been a whole lot better than the power they're now trying to claim, which brings me to my final point, that this particular power is dangerous. And why is that? Because when Congress tries to incentivize Americans to do what they want them to do, but they don't have the power to command them to do, the only consequence of Americans not doing what Congress wants them to do is they have to forgo some kind of financial benefit. If you don't want to trade your clunker in, you have to forgo the $5,000 they were willing to pay you in order to destroy that perfectly good car and drive business to the American car companies. And so that's what you have to give up. However, if this individual mandate is upheld as constitutional, even though in this case it's only being enforced by a monetary penalty, in the future, it could be enforced by the full panoply of enforcement mechanisms that are typically and historically used to enforce the Commerce Clause, up to and including imprisonment. So this mandate may seem innocuous, but the next mandate doesn't have to be, and that's why this power is a lot more dangerous than the tax power would be. Now let me conclude just by talking a little bit about the spin that you've been hearing lately, at least in the last week, about why certain conservative justices have to vote to uphold the mandate or they would be contradicting themselves. The first one, which is the most ludicrous, has to do with Chief Justice Roberts, who has said has to uphold the mandate because he signed on to an interpretation of the Necessary and Proper Clause in a case called United States versus Comstock, which involved a child sexual predators law that empowered the federal prison system to hold on to people who had been adjudicated as sexually dangerous beyond their prison sentences. And the question is, could Congress do that under its Necessary and Proper Clause? Well, in the Comstock opinion, there is narrowing language. There is narrowing language that says the law in Comstock is actually a very modest addition to existing federal power. It's an area that the federal government has occupied for a very long time. And there's a state opt-out. For any state that wants to reclaim their own prisoners, they're free to do so, so it accommodates federalism. And that's the opinion that Chief Justice Roberts signed on to. But notice this about the Comstock opinion. It had limits built into its text, the ones I just told you about. But if you hear constitutional law experts talk about Comstock now, they don't care about those limits, what was written into that opinion. They just say, oh, Congress can do anything under the necessary and proper clause now. Read Comstock. That's what's going to happen if the Supreme Court tries to limit this power by the use of some sort of textual limits like health care is different. Now, the final example I'm going to give is the one about Justice Scalia, who wrote a concurring opinion in the case that I brought to the Supreme Court, the Raich case involving medical marijuana. I must tell you I was very disappointed in Justice Scalia's vote. I was disappointed in his opinion. But in his opinion, which he concurred with the majority written by Justice Stevens, Justice Scalia relied on the necessary and proper clause. And what is said is, because Justice Scalia said in that case that because the reaching of my client's marijuana that was being grown for her by caregivers privately and not commercially, because it was essential to the broader prohibition of interstate marijuana that they be able to reach that intrastate non-economic activity, therefore it was constitutional. Let me say that again. What Justice Scalia held was it was okay to reach my client's marijuana because it was essential to a broader regulation of interstate commerce, which was the prohibition of interstate marijuana. I could say a lot more about what that means, but I'm going to, because I've run out of time, I'm just going to say one thing about that opinion by Justice Scalia. Justice Scalia's opinion, which was expressly about the necessary and proper clause, was only about the word necessary in the necessary and proper clause. The issue was whether essential to a broader regulatory scheme would be interpreted in the same deferential way as the word necessary has been interpreted in the past by the Supreme Court, meaning Congress basically has discretion when it chooses means amongst the various means that might be convenient to its end. And Justice Scalia basically adopted that approach, much to our disappointment. But here's what that opinion said not one word about. It said not one word about the word proper in the necessary and proper clause, which said, and the necessary and proper clause says that Congress shall have power to make laws which shall be necessary and proper to carry into execution its foregoing powers. There's nothing in the Raich case about the word proper. And yet it is Justice Scalia himself in the Prince case who said that the unprecedented imposition of a power to coerce local sheriffs to enforce federal law in the Brady Act by making them run gun checks, he said that was beyond the power of Congress's commerce power to enact, and he said he called the necessary and proper clause that was being offered to defend that power the last refuge of those who would defend the ultra-virus powers of Congress. And to that argument, he said, while that law may be necessary, it is not a proper exercise of power. So if there's any justice on the Supreme Court that will be very capable of distinguishing his concurring opinion in Raich from this case, it's the justice that has made the greatest use of the distinction between necessary and proper. And how will he do that? Because an individual mandate to make every man, woman, and child do business with a private company at the whim of Congress, just because Congress thinks it's convenient to its regulation of interstate commerce, is not only unnecessary, as I've explained, it is also highly improper, and for that reason, it is unconstitutional. Thanks.